In this video, let's talk about inadmissibility to Canada because of criminal offenses. But before I move forward, please subscribe to our channel and enable notifications. People could become inadmissible to Canada for many reasons, and one of those reasons, which is probably the most popular one, is having a criminal history or, in certain situations, criminal charges against a person. Before I move forward, let's talk about the criminal system inside Canada. Basically, the Criminal Code of Canada is the main act of Parliament talking about criminal offenses inside Canada. However, any act of Parliament in Canada could include provisions that cover criminal offenses. For example, the Immigration and Refugee Protection Act, which is the act that my business and my profession is built around it, has some provisions about criminal offenses. For example, offenses by the officers, offenses by the practitioners, misrepresentation issues, human smuggling, human trafficking, and so on and so forth. If somebody faces criminal offenses, then it depends on the type of the offense that we could talk about criminality or serious criminality. The first thing that you need to know is that the standard of proof by an immigration officer is reasonableness in most criminal offenses. That's why if you are facing criminal inadmissibility, you may not have an actual conviction outside Canada, yet face inadmissibility to Canada. I have an article about criminal charges and inadmissibility to Canada. I will post the link below this video. Indictable offenses are those offenses that are serious offenses, and the person who commits an indictable offense, they may face several years in prison or a huge amount of money in fines. But summary conviction talks about those offenses that are less serious, and the person may face only a few days in prison, usually a maximum of 6 months, although there are cases that you may face summary offenses and serve more than 6 months in prison. Also, of course, for summary offenses, the issue of fines is still on the table. Hybrid offenses are those offenses that under the law, it allows the prosecutors and the judges to select between summary conviction and indictable conviction. Unfortunately, when it comes to the immigration law, when we are dealing with a hybrid offense, the immigration law treats the hybrid offenses exactly the same as indictable offenses, even if they are prosecuted summarily. When it comes to inadmissibility to Canada because of criminality or serious criminality, you could face inadmissibility because of convictions outside Canada, because of convictions inside Canada, because of committing an offense or charges outside Canada, or because of committing an offense at a port of entry. Let's discuss these separately. First, let's compare criminality versus serious criminality when an offense is inside Canada. If an offense is inside Canada, then it is serious criminality if the maximum penalty in the law is at least 10 years, regardless of the duration that you serve prison. So if the maximum penalty is at least 10 years, it is serious criminality, even if the person receives 2 days in prison. The other possibility is that the person is actually imprisoned for at least 6 months or more in prison. So if the duration of prison is more than 6 months, then that person is facing inadmissibility because of serious criminality. You need to keep in mind that for offenses inside Canada, we definitely need to have a conviction, and serious criminality affects foreign nationals and permanent residents. It doesn't affect Canadian citizens. In terms of inadmissibility, obviously, Canadian citizens also face prison time and fines. So what about criminality? Criminality inside Canada happens when the person faces an indictable conviction. So one indictable conviction could result in criminal inadmissibility to Canada. Also, two summary convictions arising from two separate incidents are the cause of criminal inadmissibility to Canada. Criminality only affects foreign nationals. It doesn't affect permanent residents of Canada or Canadian citizens. When it comes to offenses outside Canada, a person could face inadmissibility to Canada either because of a conviction or because of committing a crime or charges. As I mentioned, I have another article that explains the inadmissibility because of charges outside Canada. I don't want to go into the details of that. I also have a video about it, which I post the link up here. When an offense occurs outside Canada, our focus is the equivalency in the Canadian law. In other words, we don't care that much about the duration of prison time outside Canada or the laws outside Canada. We have to find the equivalency of that law inside Canada. So if the law inside Canada says that this is not an offense, then despite a criminal history outside Canada, the person won't become inadmissible to Canada. However, when it comes to the equivalent laws in Canada, then we could find people inadmissible because of criminal or serious criminal issues. Serious criminality for outside Canada offenses happens when the equivalent Canadian law has a maximum penalty which is at least 10 years. Criminality happens when the equivalent law in Canada refers to an indictable offense or two summary convictions, again arising from two different incidents. What about offenses at a port of entry? At a port of entry, sometimes people commit offenses. If the Border Services officers decide not to charge that person and prosecute that person, to go through the prosecution process inside Canada, then that person faces criminal inadmissibility to Canada and they will be removed from Canada. However, if the Border Services officer decides to lay charges against that person will face the criminal justice system inside Canada, and whatever they encounter is the same as the first part that I talked about, criminal offenses inside Canada. Keep in mind, inadmissibility is a serious issue because if somebody is facing inadmissibility, depending on their situation, they may lose their status in Canada, they may be removed from Canada, they may be denied entry inside Canada, they may be refused their application for a temporary status or permanent status in Canada, and more. So if you are facing criminal issues, if you have criminal history or you are facing criminal charges, make sure to get in touch with a professional, and that professional can help you to resolve the issues. I have 10 years of experience as an immigration consultant. I have dealt with many issues in terms of inadmissibility to Canada because of criminality or serious criminality. And of course, I'm not an immigration lawyer, I'm a licensed immigration consultant. So when it comes to finding the equivalency of the law in Canada, I always use the help of a criminal lawyer to help me to better understand what's going on with that law. But I have the full comprehension of criminal inadmissibility to Canada. As soon as I know the equivalency in Canada, I can help you with potential resolving the problem, whether it is a TRP application, an HNC application, a rehabilitation application, deemed rehabilitation situations, authorization to return to Canada, and other similar solutions. Thank you very much for watching this video. My name is Parsai. I'm a regulated Canadian immigration consultant. I teach immigration consulting at Ashton College. I'm the author of the bestseller book, 88 Tips on Immigration to Canada. You can find out your purchasing options by visiting 88tips.ca or visiting any Amazon website. This book is available both in the print format, the paperback, and also as an ebook on Amazon websites. Please subscribe to this channel, enable notifications, like this videos, and share it with your friends. Stay safe.